930 AD. Iceland. A man named Ulfljótur has just returned from 3 years in Norway. He did not go to Norway to trade. He did not go to raid. He went to study. Specifically, he went to study law. Because Iceland, settled by Norse immigrants from Norway over the previous 50 years, had a problem that no Norse settlement had ever faced before. 30,000 people, spread across an island the size of a small European country. No king, no church with legal authority, no hereditary aristocracy with the power to enforce decisions, no army loyal to a central authority, no central authority. Just 30,000 Norse people, some of the most independently minded, most legally sophisticated, most violently capable individuals in the medieval world, living in close enough proximity that conflicts were inevitable, and far enough from any external authority that those conflicts had to be resolved internally, or not resolved at all, which meant blood feud, which meant the specific kind of escalating violence that starts with one killing and ends with 2 families reduced to nothing. Over 3 generations of revenge, Ulfljótur came back from Norway with a solution, a legal code, adapted from Norwegian law, modified for Icelandic conditions, designed not for a kingdom, but for a republic of free Norse farmers with no ruler above them. The following year, 930 AD, the Alþingi, the Althing, met for the first time at Thingvellir, the world's oldest parliament. Still meeting today, 1,093 years of continuous democratic assembly, on the same ground. And it began because 30,000 Vikings needed someone to stop the blood feuds. To understand Viking justice, you need to understand what happened without it. The blood feud. The Norse blood feud was not random violence. It was a system. A deeply structured, rule-governed, mathematically precise system for managing interpersonal conflict in a world without centralized enforcement mechanisms. Here is how it worked. A man kills another man. In most medieval legal systems backed by a king or a church or a state, this triggers an official response, an arrest, a trial, a punishment. In the Norse world, it triggered something different, an obligation. The dead man's family was now obligated to seek compensation or vengeance. To do nothing was not neutral. To do nothing was to accept the killing as legitimate. To confirm publicly that your family member's life was worth nothing. In a world where reputation was the primary currency of social survival, this was not acceptable. So the family responded. If the killer's family offered compensation, vergild, blood money, a payment of silver or livestock or land, the feud could be settled, the obligation discharged, the relationship between the 2 families reset to a neutral baseline. If the killer's family did not offer compensation or offered insufficient compensation, the dead man's family pursued vengeance, and the cycle began. Kill answered by kill. Family drawn in against family. The conflict expanding outward through kinship networks until a dispute between 2 men had consumed dozens of lives across 2 extended families. The Norse sagas are full of blood feuds, not because the Norse were uniquely violent, because the blood feud was the default conflict resolution mechanism of a world without police. And the thing, the legal assembly institutionalized at Thingvellir, was the Norse attempt to build something that could interrupt the cycle, something that could turn a blood feud into a legal proceeding, and a legal proceeding into a resolution that both sides could accept without losing the reputation that mattered more than anything else. The thing. Every Norse community had one. At the local level, the Varthing or the Leidarthing, small assemblies of the free men of a district meeting multiple times a year to handle local disputes, announce legal matters, transfer property, witness oaths. At the regional level, the Fylkesthing in Norway, larger assemblies covering broader geographic areas, handling matters too significant for local resolution. And at the top, in Iceland, the Alþingi, in Norway, the various regional things that operated at the highest political level. The thing was not a court in the modern sense. It had no judge with the power to impose a verdict. It had no police force to enforce decisions. It had no prison to put convicted criminals in. What it had was something more powerful in a world where reputation determined survival. It had witnesses. Every decision made at the thing, every verdict, every settlement, was made in front of the entire assembled community. The men of the district, the free farmers, the warriors, the traders, the people whose collective opinion constituted the social reality. You could ignore a judge's verdict. You could not ignore the judgment of everyone you knew simultaneously, because ignoring it meant something specific in Norse society. It meant outlawry, and outlawry was not a fine. Outlawry was not imprisonment. Outlawry was the removal of your legal personhood, the declaration that you no longer existed, for the purposes of Norse law, as a person with rights. You could be killed by anyone, without legal consequence, without blood feud obligation, without compensation owed to your family. You were, in the full technical sense of the word, outside the law, outside the community, outside the human world. You were sent, in a very precise sense, into the wilderness, and in the wilderness you had no friends, because anyone who helped you, who fed you, who sheltered you, became liable for the same legal consequences you carried. Association with an outlaw was itself a crime. The wilderness was not metaphorical. It was the actual Icelandic wilderness, the lava fields, the glaciers, the interior highland that no farm could survive in, the places where nothing grew and no community existed and winter lasted until it killed you. This was the Viking prison, not walls, the world itself. The outlawry system was the most powerful legal tool the Norse possessed, and it was designed with extraordinary psychological sophistication. Consider what it actually did. A man convicted of a serious crime, killing without justification, theft, or oath-breaking, faced 2 grades of outlawry. Full outlawry, skoganger, forest-going, complete removal from the legal community, permanent. The outlaw could be killed anywhere by anyone. His property was forfeit, his family connections legally severed for purposes of obligation. 3-year outlawry, Fjörbaugsgarder, a lesser sentence. The outlaw had to leave the district, or Iceland entirely, for 3 years. The full outlawry sentence was reserved for the most serious crimes. But here is what made it more effective than execution. Execution ends the problem. The dead man's family still has blood feud obligations, which can complicate rather than resolve the original conflict. Outlawry removed the problem. The outlaw who survived in the wilderness was not the community's problem anymore. He was the wilderness's problem. The Norse identity was profoundly communal. Everything that made a Norse person who they were, their honor and standing, existed within the community. Remove someone from the community, and you did not just inconvenience them, you unmade them. Outlawry was the erasure of your existence as a social being. It was, in a very precise psychological sense, worse than death. Death ended you but left your reputation intact. Your honor survived you. Your children inherited your standing. Outlawry destroyed all of it while leaving you physically alive to experience the destruction. It was the most complete punishment their system could produce. But the thing did not only punish, it prevented. The mathematics of the blood feud was formalized through the Vergild system. Every person had a legal value, a specific quantity of silver, calibrated to status and age, that represented compensation for their killing. It gave both parties a clear exit ramp, a number that, if paid and accepted, discharged the obligation completely without further violence. This was conflict management, designed to prevent the catastrophe of unchecked blood feuds from consuming entire communities. And it worked. The system persisted for 300 years across conflict-prone communities, without a police force or a prison, just witnesses, and the terror of being sent into the wilderness alone. Here is what the Icelandic sagas tell you about the thing that the celebratory accounts of Viking democracy leave out. The thing was free. In theory, every free man had the right to attend, to speak, to bring cases, to vote on verdicts. In theory. In practice, the thing was dominated by the Godar, the chieftains. Iceland had no king. But it had approximately 36 godar at any given time, powerful landowners, whose social and economic dominance over their districts translated directly into legal influence at the thing. The free farmer who came to the thing with a grievance against a powerful neighbor was not standing on equal ground with that neighbor. He was standing on ground that the neighbor's allies had prepared. Cases were won not just by legal argument, but by the number and quality of supporters you could bring to the thing. Men who would testify on your behalf. Men whose social standing lent weight to your position. Men who would stand beside you and communicate by their presence that challenging you meant challenging all of them. Justice at the thing was, in significant measure, a function of social capital, which meant it was a function of wealth, which meant it was, in significant measure, available to those who could afford it. The thrall who was wronged had no legal standing at the thing. The poor farmer with no powerful allies faced the same legal assembly as the wealthy chieftain, but not the same legal reality. The system was sophisticated. It was genuinely more accessible and more structured than most contemporary alternatives. The Icelandic legal tradition that emerged from the thing system is one of the most remarkable legal achievements of the medieval world, and it was profoundly unequal. Both things are true. The most famous case in the Icelandic sagas, the case that legal scholars still study, is the case of Gunnar of Lidarendi. Gunnar was declared an outlaw at the thing. He was supposed to leave Iceland for 3 years. He didn't. He rode to the ship that would take him into exile, got within sight of it, looked back at his farm on the hillside, and turned around. The saga records his words. He said, "How beautiful the slopes are. More beautiful than they have ever seemed to me before. I am not going." He went back to his farm and died there. Not because he was killed immediately. He held off his enemies for years. The saga describes his defense of his farmhouse, alone or nearly alone, fighting off attack after attack, with the kind of detail that communicates genuine admiration alongside genuine tragedy. He died because the outlawry had isolated him. One by one, the people who might have helped him stepped back, not out of cowardice, out of legal self-preservation. Helping an outlaw was a crime, sheltering him was a crime. And the ones who helped him anyway, his wife, his son, the few loyal friends who refused to abandon him, paid for it. Gunnar died on his beautiful slope, looking at the farm he could not leave, because the system worked. The thing had declared him outlaw, and the world had obliged. In June of every year, in Thingvellir, Iceland, the Alþingi still meets. Not in the same form as 930 AD, not the open-air assembly of free farmers on the volcanic plain, the law speaker reciting the legal code from memory on the law rock. The godar negotiating in their booths, the blood feuds being settled, or not settled in the shadow of the great Rift Valley walls. The modern Alþingi meets in Reykjavik now, in a building, with elected representatives and parliamentary procedure, and all the apparatus of a modern democratic legislature, but it traces its lineage directly to 930, directly to Ulfljótur, coming back from Norway with a legal code, and 30,000 independent-minded Norse settlers deciding that some mechanism for living together without destroying each other was preferable to the alternative. The oldest parliament in the world, still functioning, still making law, on the same institutional foundation laid by people who had no model, no precedent, no template, no existing example of a republic without a king, just the practical recognition that the blood feud was worse than compromise. Think about what that recognition required. In a culture that celebrated individual honor above almost everything else, in a world where backing down was weakness, and weakness was death, and the reputation for strength was the primary currency of social survival. To say, we will accept the thing's verdict even when we disagree with it. To say, we will pay the compensation. To say, we will send our kinsman into outlawry even when we love him. Because the alternative, the endless compounding of blood, is worse. This is not a small thing. It required the willingness to subordinate the individual demand for personal justice to the collective need for sustainable community. Ahmad ibn Fadlan found the Norse difficult to categorize. They were not what he expected from barbarians. Too sophisticated, too legally aware. He wrote about it. He was watching a civilization in the process of solving one of the hardest problems any human community ever faces. How do you live with people who have the capacity and the willingness to kill you? The Norse answer was the thing, where everyone spoke, where the law was spoken aloud so that everyone heard it and none could claim ignorance. The law rock at Thingvellir, where the law speaker stood for 300 years to keep the law alive in human voices, is still there. A flat shelf of volcanic basalt. Unimpressive to look at. The kind of rock you would walk past without noticing. Unless you knew. The law is in the speaking. The Norse understood this. The law is not in the text. It is in the act of saying it out loud, so that the wilderness remains what it always was, the place for those who could not live among people, and the community remains the only alternative.